My comments here are not meant to be a disparagement of Rick McKay, your enforcement officer, or the commission itself. I'm here because I feel that I need to make a criticism and objection to what we determine to be a flawed procedure, and I'll explain why as we go. So if I may be so bold as to read this into the record, and I'll be happy to answer the questions we go through. I'll be as quick as I can. Mr. Chairman, this is a response to several complaints that have been made to the First Selectman's Office and the Conservation Commission regarding removal of trees on the above referenced property, which is 209 Sharon Road, Salisbury, Connecticut, which both we and our client concluded was resolved at our appearance before the Salisbury Conservation Commission on March 6, 2017. Enclosed for review are the minutes of March 6, 2017 Salisbury Conservation Commission attached here to Exhibit A. By way of review, we've also enclosed for review, which are photographs taken from the property showing the remaining trees and multiple rows of silt fence and Filtrex stocks installed to prevent erosion. The photographs were given to the commission, I believe, at the previous session on March 6th, and would be referred to as Exhibit B. It is the position of the owner, Quentin Van Duzelaire, in our office that the activity engaged in was done as a matter of right, and as such requires no Salisbury Conservation Commission review or approval. In all the years of practice by this office before the Salisbury Conservation Commission, no client has ever been required to seek permission from the commission for the removal of select trees in order to enhance the view of the lake from the owner's residence. As the activity of this property is permitted as a matter of right, and as such there is no regulation in the Salisbury Conservation Commission regulations requiring the property owner to make or submit any application or review request before the Salisbury Conservation Commission. The following is a review of the applicable Salisbury Conservation Commission regulations. Section 4 of the Salisbury Conservation Commission regulations states permitted and non-regulated uses. Section 4, permitted uses as of right and non-regulated uses. 4.1, the following operation and uses shall be permitted in wetlands and watercourses as of right. Emphasis added. D, uses incidental to the enjoyment and maintenance of residential property. Such uses shall include maintenance of existing structures and landscaping. Emphasis added, but shall not include removal or deposition of significant amount of materials from or onto the wetland or watercourse, or diversion or alteration of the watercourse. As is apparent from the regulations above, the cutting of trees to enhance or create a view of the water is a right available to the owner as landscaping as a matter of right, an incidental right of ownership that allows him to adjust or modify his landscaping or trees as desired to enhance or change the view of the lake without the need for review or permission from the Salisbury Conservation Commission. There was no removal or deposition of any material from or onto the wetland or watercourse, or diversion or alteration of a watercourse, so by definition, the activity took place as a matter of right, as part of legitimate landscaping endeavors to allow the property owner to view a lake, something nearly all other lakefront owners enjoy. The only prohibition from cutting trees involves the clear cutting of trees that is clearly and narrowly defined in Section 2. Section 2 definitions 2.1. As used in these regulations, clear cutting means the harvest of timber in a fashion which removes all, and emphasis added, all, trees down to a 2-inch diameter breast height. As shown from the enclosed photos, which are Exhibit B, all trees were not removed, and many of the large diameter trees have been preserved. There remains on the property a large number of healthy specimen trees. Nearly 2 months ago, a claim was made that there should have been an application, or at least a request, by the owner for a ruling that the activities are permitted. The applicable regulation is Section 4.4. However, in order to interpret Section 4.4, one must look at the preceding sections for guidance. Enclosed, please find the key language in bold and delineates what is required to be brought before the Conservation Commission. 4.2, the following operations and uses shall be permitted as non-regulated. Emphasis added, wetlands, watercourses, provided they do not disturb the natural or indigenous character of the wetlands or watercourses by removal or deposition of material, alteration, or obstruction of water flow or pollution of the wetland or watercourse. A, conservation of soil, vegetation, water, shellfish, wildlife. And B, outdoor recreation including play and sports areas, golf courses, field trials, study natures, hiking, horseback riding, swimming, skin diving, camping, boating, water skiing, trapping, hunting, fishing, shellfishing, or otherwise legally permitted. And 3, all activities in wetlands or watercourses involving filling, excavating, dredging, clear cutting, clearing or grading, or any other alteration or use of the wetland or watercourse not specifically permitted, emphasis added by this section, emphasis added, and otherwise defined as regulated activities by this regulation shall require a permit from the agency in accordance with Section 6 of these regulations, or for certain regulated activities located outside of the wetland and watercourses from the duly authorized agent in accordance with Section 12 of these regulations. 4.4 goes on to say, to carry out the purposes of the section, any person proposing a permitted operation or use or non-regulated operation and use, emphasis added, shall prior to the commencement of such operation and use, notify the agency and a form provided by it, and provide the agency with sufficient information to enable it to properly determine that the proposed operation and use is a permitted or regulated use of a wetland or watercourse. The agency shall not rule that the proposed operation and use or portion of it is a permitted or regulated operation and use, emphasis added, or that the proposed operation and use is a regulated activity and a permitted required. Nowhere in any of these sections above quoted are as of right uses discussed. The Conservation Commission regulations define 3 separate activities. 1, as of right; 2, non-regulated operation and use; and 3, specific permitted operation and use. Only 2 and 3, as described in sections 4.2 and 4.3, require an owner of a property to appear before the Conservation Commission, submit a completed form with sufficient information for agent determination. As of right usage is not included in section 4.4, which requires agency involvement. If the Salisbury Conservation Commission had wanted to include as of right activities to require an application, review and decision by the Salisbury Conservation Commission as contemplated by section 4.4, the Commission could have easily drafted and included that language in the section. The implementing authority for the regulations did not do so when the regulations were implemented. The Commission has not amended the regulations to require such application, and therefore the Salisbury Conservation Commission cannot now attempt to enforce usage not specifically delineated in the regulations merely because of public pressure or complaints from disgruntled lakefront property owners. Further strengthening our client's position that no application or approval was needed is an email from Darcy Winter of the Connecticut Department of Energy and Environmental Protection, attached here to as Exhibit C, that was in response to an email from Mary Silks, attached here to as Exhibit D, to the Connecticut Department of Energy and Environmental Protection, claiming that there are threatened and endangered species located on the subject property. Exhibit C in the 3rd paragraph states, and this is from the Department of Energy and Environmental Protection. The Department of Energy and Environmental Protection, DEP, recommends that a municipal inland wetlands agency establish a regulation stating that any person proposing a permitted as of right, emphasis added, use and operation and use, or non-regulated activity, and you shall, prior to the commencement of such activity, notify the agency in a form provided by such agency, and provide sufficient information to enable the agency to determine the operation and use, to determine if the operation and use is exempt. Therefore, please consult Salisbury's inland wetland regulations for additional information. Should that consultation with the Salisbury Conservation Commission regulations have taken place, it would have been painfully clear that there exists no such regulation or requirement in the Salisbury Conservation Commission regulations. As is evidently clear from the review of the Salisbury Conservation Commission regulations, there is no section anywhere in the regulations that mandates, requires, or even suggests that a property owner must file an application with the Conservation Commission for an activity performed by an owner as a matter of right. As such, the property owner had and continues to have no legal requirement to present any plan or action for his property to the Salisbury Conservation Commission before engaging in any of as-right activity. A closer look at Exhibit A, March 6, 2017 Salisbury Commission minutes reveals that the Commission determined that there was no violation of its regulations and therefore took no action, and one commissioner stated that from that point forward he would like to see the procedure changed, which is a future action. Attorney Mark J. Capisolantro informed the Commission that he would get details of the landscaping to be done. There was no further action needed or contemplated by the Commission. Therefore, the cease and correct order attached here to as Exhibit D comes as a complete surprise and is only in response to a letter from Mary Silks, an owner of a property on the lake, who took it upon herself to file a complaint that is void of any substantive evidence for which a cease and correct order could possibly be issued. In an email dated March